viral video recently showed a couple, a man and a woman, seen thrown to the ground, screaming and pleading for mercy in West Bengal's North Dinajpur, as they are whipped with a broom. The man leading the assault was identified as Tajmul alias JCB, reportedly a TMC leader of the Chopra area. Why? Because the two were reportedly in an extramarital affair. Decisions taken in a Saileshi Sabha, equivalent to kangaroo courts. A group of people enforcing their version of morality or immorality by violating law, worse, using violence to establish their sense of justice. In fact, injustice. A woman today died by suicide in Jalpaiguri after she was beaten up by a group of people from her village panchayat in the Fulbari area of West Bengal's Jalpaiguri district for allegedly having an extramarital affair. Some women from the village beat her up in front of the panchayat. I complained to the police that my wife died because of these women, as she could not bear the humiliation of being summoned to the kangaroo court and being beaten up publicly. These were the words of her husband. And there are other instances as well. Now let's just shift focus a little bit away from West Bengal, and we'll return to West Bengal and the kangaroo courts, the instances around it in a bit. But just let's shift gear for a bit. In another instance of a horrifying attack in Lucknow, a 21-year-old woman was attacked by a stalker today who threw acid on her, injuring her and her cousin. Both have been hospitalized. The accused is on the run, and the attack happened in broad daylight in a busy intersection in the heart of Lucknow. 2 days ago, a 16-year-old was stabbed in Jabalpur by a 17-year-old jilted lover, again in broad daylight. Remember, it's a new set of criminal laws that have been enforced in India. But what has changed, or rather what will change? We look at these new laws from the prism of women tonight. But returning to Bengal, from where we were looking at instances of kangaroo courts and their sense of justice, rather injustice, as I'm repeatedly saying. There's a Bengal Anti-Lynching Bill 2019 which is pending governor's assent. It aims to prevent and punish mob lynching. But does injustice, attacks and mob justice come under mob lynchings, particularly under the new law? We try and understand all this with our panel of experts, and as I said, kangaroo courts have several versions and identities. Cup panchayats, Maoist trials, honor killings, so many names, zero transparency, no accountability, warped loyalties, unfair hearing, if at all any, swift, harsh punishments, often taking law into their own hands and motivated by mob mentality. Of course, never forget, often enjoying political patronage. Amit Shah in the parliament recently claimed that with the overhaul of the colonial era criminal code, an Indian soul has been added to the justice system on crimes relating to violence against women. Mr. Shah said the new law provides for recording the survivor's statement at her home and also mentioned an online FIR facility that will shield her from social stigma. But let's do a reality check. I'm going to be joined by my panelists, my experts. Right now, we have got Talish Ray, who's an advocate. Thank you very much, Talish Ray, for joining us. Would you help us understand, firstly, when we talk about the instances that are coming in from West Bengal, or even other instances, we'll come to that in a bit. But let's just look at these kangaroo court injustice, if I can. I don't even want to use kangaroo court justice for that matter. Is there a change in how this is going to be looked under the current law and the earlier law?
Uh, Good evening, Sneha. Thank you for actually not using the word courts around, this manner of mob violence. There is no other way to describe it. When we look at the spectrum of laws that exist around it, I think the first thing that we must make a mention of is the judgment of the Supreme Court in Poonawalla versus Union of India, wherein the courts, in the absence of, and they actually observed a lot of things. They said that there cannot be an investigation, trial, and punishment on the street. They had also laid down that there is no shadow of doubt that the authorities which have been conferred with the responsibility to maintain law and order in the states have the principal obligation to see that vigilanteism does not take place. So these were very, very strong terms they laid out thereafter. In effect, a certain amount of guidelines that were there, which talked about a nodal officer, which is not less than the rank of an SP, assisted by a task force that was going to do intelligence gathering as well as regular meetings, plus, senior officers of the state constantly meeting with those people, the nodal officers. And it was basically on the basis of that there was also a bill that was introduced, which was called the Mob Lynching Bill of 2022, which had been introduced by an MP in the parliament. However, that is yet to see the light of the day. And then we, of course, come down to and this bill that was introduced basically adapted a lot of the things that the Supreme Court had laid down in the Poonawalla judgment. And then, of course, we now have the Nyaya Samhita, which under 103, specifically subsection 2, talks about mob lynching and makes it effective, where it says that a group of 5 or more persons acting in concert commit murder on the grounds of race, caste, community, sex, place of birth, language, personal belief, or any other ground. Each member of such group shall be punished with death or with imprisonment for life, and shall also be liable for a fine. Now, to bring it to your notice, the IPC did not have any section that covered this manner of a mob of 5 or more people getting together, and neither did it recommend this kind of a stringent punishment. So that definitely is a welcome change. But is it enough? That remains to be seen, because when we see instances of that mob violence, like in the current case that we see, it could just be the sheer humiliation which causes people to then either self-harm, or, a lot of the times there are murders that take place which are passed off as self-harm and suicide. So clearly there is a lacuna that is there, and one lives in the hope that gradually, as the Bharatiya Nyaya Samhita has introduced this section, along with the reading of the Supreme Court, it is going to lead to some sort of a shift that takes place. But another word that I must put in here, Sneha, and I think that is very important. Law is derived from the society that we are in. And to think that a law can change what a social, sort of the social thinking is a difficult one. Laws do not bring about those manner of shifts that are there. Though that shift has to come from within us when we are responding to things, how we respond to violence. And it becomes rather sad, because come to think of it, we are the country that taught the world non-violence with our Gandhian protest. And yet we have a society that's currently just aiming for everyone's blood the moment they think that they need to deliver some manner of vigilante justice in the name of upholding either their community standards or any such things which have been decided locally. So that does not bode well for the rule of law. But rule of law has to be imbibed by the communities that we are a part of, by the society that we are a part of.
All right. Tausif Ahmed Khan also joins us right now. Tausif, there's nothing which is isolated from politics, as it were. But I'm calling you here for a very simple reason, because you're also from West Bengal. And it's important for people to understand. And as I explained, you joined us late, but let me just try and explain to you. We are looking at what's unfolding across the country, including West Bengal, including the latest instances of kangaroo courts with the prism of the new law. But before I even get into that, Tausif, would you help us understand Why is it so deep rooted in a state like West Bengal? And I'm not saying this is only isolated to West Bengal. Nonetheless, the latest cases are from West Bengal. Why isn't the government able to tackle this? In fact, there are TMC men and elected representatives who seem to be involved in this directly, indirectly as well, both the cases. So why isn't the government able to tackle this? What's the challenge?
You see, 5 years ago, Bengal Assembly passed a bill, anti-lynching bill, and the bill had been lying with the governor. Governor has not given assent to the bill, and therefore the bill was not in force. Now, the reason the bill was the bill was passed by the Bengal Assembly 5 years ago because of the environment prevailing in the country at that time, wherein all the neighboring states like in Uttar Pradesh or in Jharkhand and Gujarat and elsewhere in Haryana, so lots of mob lynching incidents were reported. And Supreme Court took cognizance of that. In the Poonawalla judgment, it was suggested that state government as well as central government should pass anti-lynching law with stringent punitive actions, and also recommended a very, very important point here, because in India, whatever happens is because of the system that is there in practical life. So what is the system? The change that the judgment wanted to bring in the system, that incidents of mob lynching will be investigated under direct supervision of a senior police officer of the rank of SP and commissioner in urban areas. And therefore, these laws were introduced. But the BJP did not. Obviously, we know the governor of West Bengal is the representative of BJP and takes direct instructions only from BJP. Then only they act. Therefore, this law was never passed in. Had this law been passed from last 5 years, we all understand that this would have played a great role as a deterrence, great role in preventing any future mob justice incidents, any future kangaroo case incidents, any future, killing of people on road by mob. It is, so horrific a scene to see in today's world, when we see that a man is lynched, a woman is lynched, or a couple, as it happened in Bengal, were being flogged. You can imagine a cricket match was happening in Gujarat.
I mean, I know you're making a political point, and I know, in fact, we have the graphics on our screen as well about the Bengal anti-lynching bill that has been introduced but is pending before the governor. We have all the details of that on our screen as well, even as you speak about that. But my point is also beyond that. Does the government recognize that the rot, and it's a very simple thing, the house needs to be cleaned from within. Does the government recognize that the rot goes deep, not only in the society, but even within its party?
No, the government recognized that action has to be taken, and therefore, it is the Bengal government which passed this anti-lynching law. And now contrast it with Gujarat, where lynchings are happening from so many years. They never even bothered to pass a law. Their assembly never passed any bill. At least in Bengal, we have Mamata Banerjee government which took a proactive step. On the same year when the Supreme Court had passed the judgment, the bill was introduced. For political reasons, yes, the BJP did not allow that bill to come into force.
Okay, I'm also being joined by Karuna Nundy at this point. Karuna, beyond politics, beyond the back and forth that really happens in politics, there's one thing that we are trying to understand, and I also asked this question to Talish Ray as well. Do you see a change in how mob injustice, and we are using the word mob injustice here, not mob justice, mob injustice is meted out to people who do not conform to their ideas and notions, and in most cases it is women? Do you see that happen with the new law? Is there any substantial change when it comes to that?
So Sneha Kohsy, the thing to remember is that in this particular case, it was about an extramarital affair, right? And that extramarital affair used to be called adultery under the old law. So a bit of sort of constitutional extrapolation here, which is that the Supreme Court, 5 judges, said that you cannot, we are going to strike down this law because it doesn't respect women's bodily autonomy. Now, why would you say this? Is it that women should be cheating? No. Is it that men can't, file for divorce if a woman is cheating? No. However, the way that that law was framed, Section 497, was that women were essentially treated as property, right? Which is that if a man cheated, he could not be prosecuted. The woman herself was not prosecuted, but the man who slept with another man's wife was prosecuted, right? Now, that was struck down by the court and it has been brought back by the Bharatiya Nyaya Samhita. And what did we see in this, completely egregious Kap Panchayat, in which apparently Trinamool Congress member of the, a member of the ruling party had a part, is differences, of course, between the Bharatiya Nyaya Samhita provision and this. But there is one similarity in that the woman is being treated as property. The woman's freedom to choose her partner is not being respected by the criminal law. So the freedom, the bodily integrity that was recognized and respected by the Supreme Court is being done away with in both situations. So that is a problem. And separately, of course, beyond political lines, stepping aside from any politics that I don't really get into, regardless, is that across the board, we see people from the parties in power not being prosecuted, but in particular, when the crime involves a woman or a Dalit or somebody from a minority religion, people with less power, And I think that the Trinamool Congress has been doing extremely well in Parliament if they really want to stand for justice and if they want to make clear that they are different from the BJP in Hathras or the BJP in the little girl's case in JNK, then they should really put their money where their mouth is, because there have also been other cases of serious egregiousness in this regard by the TMC. And the TMC has a bit of a reputation for this now. So they need to clean up their house.
Right. Talish Ray, while both of you tried to explain to us how there could be little different variations in how this is being looked at and the challenges that come with it, we also mentioned about this case of an acid attack in Lucknow. Now, the Home Minister in the Parliament, several ministers in the Parliament have gone ahead and said that at the heart of these new laws is justice, is reformation. At the heart of these new laws is speedy trial and putting women and children first. What changes when it comes to trial that has to go on with the way it will unfold? Now, of course, we can't go into case specifics, but largely if you look at what happened in the acid attack case in Lucknow, where a 21-year-old was attacked with acid by a stalker, is there any specific changes that say that things will change henceforth?
So, Sneha, let me first start with one thing. When we start looking at the changes and how it is going to come in, I think the critical term to be remembered is that Chapter 5 actually does great disservice when it clubs, again, women and children together. Please, let's take that, that itself is a step backwards, because that was a sort of recognition that was coming in that women and children cannot be clubbed together. For multiple reasons. Now, so far as when we look at the procedural part of it, there are certain norms that have been brought about in the procedural law, which would seem that it might become faster. But I think we also need to have a look at various other things that are there, including how the legal infrastructure would be able to take the kind of pressure. Because the rate of crime against women per se within the territories of India is so high, and I'm not even talking about the ones that are not reported. I'm just talking about reported crime. At that point in time, you look at a legal system which is completely overwhelmed. So then the question arises that what do we do with the recommendations that came in with the Justice Verma Committee, which specifically talked about fast track courts? Now, we don't see all of that. So it will remain to be seen whether procedurally, when the new procedures have come in, will it mean a far more impactful or speedier justice that will come about? That will remain to be seen, because it is very, very early in the days to see whether what is being spoken of, and even as we speak as lawyers, we're still analyzing as to how this is going to roll out. So that's basically contemplating in the realm of the future. So that's all that I would have to say on that one.
Karuna Nundy, do you agree with what Talish Ray said at the starting, that clubbing women and children in chapter 5 together is in itself a wrong start?
Of course, because the idea, it infantilizes women for a start, and it doesn't address the very specific vulnerabilities and needs of children. So it does an injustice both ways, right? It also emerges from a time that women and children were sort of thought to be part of the family and products of the home. So yes, absolutely.
Just continuing that, Karuna. So, Karuna Nundy, as people, as viewers who would be watching this program, and as we are in the cusp, we're literally in the intersection where you still have the old laws, because you'll be having cases which are going to be tried under those sections, and you have the new laws starting first. Now, for viewers who are watching, between all the political back and forth, of course, the opposition is saying it's just cosmetic changes. There's nothing concrete that has happened to all of this. What should the viewers' takeaway be at this point? Should they believe the opposition or should they believe the law? I'm not saying opposition and the ruling. I'm saying opposition and the law.
I don't think they should believe either the opposition or the law. I'm a firm believer that people should read for themselves, And the thing is that 85% of the laws are identical to the old laws. However, Shri 420 will no longer be Shri 420. Richa Chadda's film, that she very kindly said was in part inspired, the character was inspired by some of my work, 375 was not, it will not be 375, 376 anymore. 302, those things that even the general public knows, right? So even lawyers are going to have to learn new numbers. And also, even if one word is changed in the criminal law, the entire law changes. So everyone is learning fast in that regard, because the cases are going to come and they're going to come fast. But what are the broad, big takeaways? There are some improvements in procedural law. There is that time limit for a judgment. I don't think it is actually going to work, because the big problem is the infrastructure. We have the lowest number, one of the lowest numbers of courts and judges per population in the entire world, right? It's lower than Ghana. Now, Ghana it's not a great example because Ghana is fairly well administered, but it's lower than a number of sub-Saharan African countries, right? Sedition has become so broad that if you excite feelings of separatism, right? You can go in for sedition. The penalties have been increased, and that's a problem. Technology has been incorporated a bit more, so that's a good thing. And we have challenged a provision of the Bharatiya Nyaya Sanhita in the Supreme Court, the one on marital rape, because that is identical to what Lord Macaulay drafted, in the 18th century. It's identical. It's actually worse than what Lord Hale imagined in, even centuries before that. So, yes, there is a bit of progress. There is also significant moves backward. But yes, let's watch this space and we will explain as the cases come up more and more how the laws are developing.
Talish Ray, I'm out of time, but very quickly, my last question, a minute to you possibly. What about people when there's a kangaroo court verdict playing out, when there is somebody who has taken law into their hands and people are all around? They may not be directly involved in the act that is being committed, but they are around. They're patronizing it with their presence, possibly recording it on their cell phones. Are they also part of mob lynching or mob violence?
Yeah, so according to the new 103 subsection 2, so the word that is used is acting in concert. And therefore, those that are around seemingly acting in concert, and that will have to be obviously defined, would be a part of that. When we're looking at the aspect of somebody recording it, it would depend on what the role of the person is beyond recording as well. Sometimes those recordings are done in order to circulate what is, or in order to cause what is known as a chilling effect. Like, hey, look, this happened in the next door village and this can happen to you. Or is it being done under a certain journalistic privilege? So that would differ in that sense. But if somebody is present, they could be, and it could be that they're not participating in the violence, but they might just be inciting the violence, in which case they would be covered under this.
Right. Karuna Nundy as well as Talish Ray. Karuna Nundy, you differ with this? Do you want to quickly take make a counter as well? A minute to you.
Just very quickly, this jurisdiction is actually quite different from jurisdictions like the French, which is that there are very, very few times is there any penalty under the criminal law for not acting, right? So acting in concert or conspiracy or aiding and abetment would mean that either there has to be a prior plan, or that, to act in concert and further a common goal, which is the common goal being criminal, or there has to be an act that furthers, aids, or abets the criminal act. So just standing there, for better or for worse, this is where our jurisdiction is at the moment, would not be an act in concert.
Okay. Karuna Nundy, Talish Ray, thank you very much for joining us and for giving us, helping us understand this better. It's of course very complex, but we'll see how this plays out in days and weeks to come. Hopefully we will see better versions of justice as well. Thank you very much for joining us. Also joining us right now is Rajya Sabha MP and former Union Minister P. Chidambaram, veteran Congress leader. Thank you very much for joining us. A lot has happened in the Parliament, but if you look at outside the Parliament, you have the new criminal laws that have been enforced now. Of course, it did not have the kind of heated debates that the Parliament is witnessing right now. Nonetheless, how do you look at them? What are your big concerns?
The way the 3 criminal laws were passed and the way they are being implemented, we are not happy at all. In fact, there is stiff opposition to the manner in which the laws were passed and the manner in which the laws are implemented. My fear is, in the short run, there will be utter disarray in the administration of criminal justice. Each court will interpret it in its own way. Each high court will take its own view. And by the time this is all resolved by the Supreme Court, several months of utter disarray and confusion. In the medium term, several provisions of the laws will be challenged in various courts. And in the long run, every state government will come to the central government saying, since the matter is in the concurrent list, let the state legislature introduce its own amendments. And then there will be a further battle, which amendment of which state should be accepted by the central government and which amendment of which state should not be accepted. That is because the manner in which the laws were drafted and the manner in which they were passed.
Okay, you're mentioning about states moving amendments. In fact, Karnataka has already gone ahead and said that they will be moving an amendment. How is this going to play out on the ground? Do the states have that kind of right to go ahead and seek for amendments, or will this be a resolution? How is this going to play out on the ground?
See, the criminal law is a concurrent subject. Both the parliament and the state legislature have the jurisdiction to pass laws. And in fact, the Indian Penal Code, the Criminal Procedure Code have state amendments approved by the central government under Article 254. Therefore, every state is competent to pass an amending law. It is not a resolution. They will pass an amendment law. But the law has to be submitted to the central government for a president's approval under Article 254. And normally this central government will grant approval to the state amendment, which will be in force within the territory of that state. It will not apply to another state. But what attitude this government will adopt, I can't say. If a BJP government brings an amendment, and if a non-BJP government brings an amendment, what standards they will apply, I don't know.
Mr. Chidambaram, look at these kangaroo court cases that are playing out, the absolute injustice that's being meted out. Look at the crimes that are against women. Just today we saw about how there was acid being thrown at a woman. There are claims that at the heart of all of these, it's women. There's justice for women at the heart of all these new criminal laws. Do you see, do you agree with this?
What is the change? Please read my dissent notes and the dissent notes of other MPs who are members of the committee. I can demonstrate to anyone that 90 to 95% of the old Indian Penal Code text has been copied and pasted in the new law. 95% of the existing text of the Criminal Procedure Code has been copied and pasted in the new law. 99% of the text of the Indian Evidence Act has been copied and pasted in the new law. If the copy and paste amounts to 90 to 99% of the existing laws, what is the change you've brought about? It's all hype. What is the change? You've made some changes, one or two changes, we have welcomed it. But you have made some changes, you have also made retrograde provisions. Therefore, what should have been done is, if you are keeping 90 to 95% of the existing text, you should have only taken the existing law and brought about amendments. The amendments would have focused on the issue whether the amendment is an improvement or whether the amendment is a retrograde move. Instead of that, you've passed a so-called new law. It is not a new law. Every section has been renumbered, but the text is the same. And you are burying under this mass of words the few retrograde provisions and the few improvements. We have nothing against the improvements, but what about the retrograde provisions? What about the provisions which are no longer consistent with modern criminal jurisprudence? For example, death penalty has been retained. Solitary confinement has been added, which is another retrograde provision. It is a cruel and unusual punishment which is abolished all over the world. Then you have kept sedition, just given a different number. Therefore, there are serious issues with the changes you have made and buried it in an existing text with different section numbers.
Right. Mr. Chidambaram, thank you very much for taking out time and speaking to Mirror Now. Thank you.